Good morning, Mr. Chair. I'm sitting over here, and I have arrived. Good morning, Excellencies, ladies and gentlemen. My name is Beate and I'm heading the Special Action Program Against Forced Labor of the International Labour Organization, which I think, as you all know, is a specialized UN agency based in Switzerland, but with a global presence. My presentation this morning is about change. And I hope by focusing on change, I can inspire you and give us all a sense of hope that despite of the tremendous challenge that is ahead of us, meaning eliminating slavery, that it is actually possible. It is a daunting task, but possible. The topic of this academy, issues beyond criminalization, is a very timely topic, a very important one, because, and I want there to be no misunderstanding, criminalization is very important strategically. It is important to define the boundaries between socially acceptable behavior and to hold those account who violate those norms, and to address deeply rooted practices of abuse and exploitation. But in itself, criminal justice is not enough. It needs to be embedded in a broader system of social justice, and this is the focus of my presentation this morning. The vast majority of the estimated 21 million men, women, and children in forced labor, they are not slaves of brutal warlords, although we do see, sadly, a resurgence of those practices in recent times. They are mainly in the informal economy, and they are also working in mainstream economic sectors. They are tied to their workplaces by very subtle means of coercion and exploitation. In other words, their exploitation is not the result of some deviant marginal behavior. Rather, it is very much part and parcel of contemporary labor relations in our economy. And the fundamental injustice they suffer is to be deprived of what economists call a fair share of their marginal product of labor. In other words, not being paid a fair wage or not being paid anything at all for their labor. And they are subjected to various degrees of coercion by those who have control over their lives. Feudal landlords in some parts of the world, tribal chiefs, unscrupulous labor brokers, corrupt state officials, but also companies and suppliers in global supply chains. So I want this to be really center stage, that this is part of our economic system. Now, the historical evolution of legal concepts and definitions have, of course, changed attitudes and behavior. The evolution of norms against slavery was very much part of a broader social system, social movement starting in the 18th and 19th century, which acted as a catalyst to the development of international labor law. And this broader dimension of labor justice and human rights makes action against trafficking and modern slavery very effective from a long-term perspective. I will not go into detail on these issues of the different legal concepts and definitions. I just want to say it here, the concepts of slavery, forced labor, and human trafficking, the three of them are distinct legal concepts, but they have more in common than what is often acknowledged. So I will, in the following of my presentation, mainly talk about forced labor, but you can as well call many of those forms of forced labor trafficking or slavery, whatever concept is closely to your cultural background also. Let us, for a moment, go back in history and see how those norms and changing norms have had an impact on the elimination of forced labor in some parts of the world. Following the adoption of the Slavery Convention in 1926, the League of Nations asked the ILO to develop standards focused specifically on forced labor in the colonial context. Because when slavery was eradicated, or at least prohibited, starting in the 19th century, coercive labor practices did not disappear. There was still a need for cheap and exploitable labor. They just transmuted and changed into other forms of exploitation. And mainly forced labor that was used in colonial countries and territories. And that's why the ILO's Convention on Forced Labor was adopted in 1930. The convention for the first time defined forced labor as all work or service which is exacted from any person by using the means of penalty and involuntariness. So there's an element of involuntariness and the lack of consent in this definition. The interesting part of this convention is that it considered forced labor to be still acceptable in a limited sense during a transitional period. So the drafters of the convention were not convinced that it was possible to immediately eliminate all forms of forced labor, but instead thought it had to be abolished gradually. And they may have been overly optimistic regarding this transitional period. They thought it would be enough to give countries 5 years to eliminate systems of forced labor. Now, the story I'd like to tell here shows you how challenging it sometimes is to change those practices and attitudes. And this is the story of the country of Ghana, which submitted a complaint against Portugal in the 1960s, accusing Portugal for the continued use of forced labor in its colonies, in particular in Angola, Mozambique, and Guinea. The ILO set up a commission of inquiry in 1961, and the commission published a very strong report with a lot of evidence showing the continued use of forced labor in those countries. So there were serious allegations against the government of Portugal. And I would like to read what the government of Portugal at the time in 1961 responded. And I'm quoting from the historical report. Some backward peoples do not experience needs which impel them to work, although it might be said from the point of view of social policy that these needs do in fact exist. Leaving these communities to determine their own needs without requiring from them greater effort than is involved in satisfying their inclinations as they like would mean promoting their aversion to barbarism and leaving them at the mercy of all the evils which decimate them. Now, today, none of the former colonial powers would use such crude justification for the use of forced labor. We clearly see how the mindset of governments has changed over the years. And last year, in the ILO, governments, workers, and employers adopted a new legally binding protocol which effectively eliminated those transitional provisions and which modernizes the ILO convention which was adopted in 1930. So there will be no misunderstanding anymore. Any form of forced labor will have to be strictly prohibited, and those transitional provisions will then become a footnote in our history books. So now let me take you to the present. What the ILO can share with you in terms of where we see progress and change. Just a very brief introduction, and again, I will not bore you with detail, you have it in my paper, but just to have a shared understanding of how the ILO works. Essentially, we are a standard-setting organization. We are a normative organization. We have 189 international conventions, 6 legally binding protocols, and 203 recommendations. So it's a rich body of international law. Most of it focuses on labor law, not on criminal law, with the exception of the ILO's Forced Labor Convention. and also the Convention on the Worst Forms of Child Labor to some extent. Attached to the system of conventions and standards is a very effective treaty body supervisory system. It's one of the most effective systems of the UN system for the main reason because it's not just handled by governments, but workers and employers' organizations, meaning non-state actors, can actually participate in the system and can submit complaints. And in fact, in most of the complaints we receive, workers play a catalyst role. It's workers themselves claiming their rights through the international trade union movement. And it's because of the supervisory system that many egregious forms of forced labor were addressed in history, and I just gave you the example of Portugal and its colonies, Angola, Mozambique, and Guinea. But in addition to the normative system, the ILO has a very strong operational capacity. We have country operations currently in more than 60 countries where we effectively focus on forms of slavery, forced labor, affecting adults or children or both. And it is through the presence on the ground and through these operations in different countries that we can actually make a difference. So we are linking the supervisory system, the normative standard setting system, to concrete action on the ground. And the stories of change I'd like to share from recent years, and again you'll see more in my paper, are from different regions. I have given you the first example from South Asia, where we have worked for more than 20 years to address entrenched forms of bonded labor, affecting mainly low-caste groups in India and minorities. This is a very complex story which I will not aim to tell here because I know time is short. So I would encourage you to read what the ILO has done to address bonded labor. I'd like to share the story of the eradication of the trafficking of children for camel jockeys in the Middle East, which I think some of you are familiar with, but just it's a good illustration of how normative action can change behavior and essentially eliminate a system of forced labor and trafficking. Now, the case of camel jockeys, those of you not familiar with, it involved the trafficking of children from poorer countries to Middle Eastern countries, in particular the United Arab Emirates. And these children were used to ride the camels in camel races, which is a very popular sport. And the implications for the children were terrible, of course, for their health. Some died, many were taken out of their family at a very young age. So the issue came to the attention of the international community in early 2000, and the Anti-Slavery International, an NGO I think you're familiar with, collaborated with the International Trade Union Confederation to prepare, to submit the information to the ILO supervisory system. And the communication that they've submitted was duly taken into consideration by the ILO supervisory bodies. And the supervisory bodies requested the United Arab Emirates to accept a direct contacts mission. This is a high-level mission. And the case was then discussed at the Committee on the Application of Standards, which is a high-level committee meeting once a year at the International Labour Conference. The government of the United Arab Emirates accepted the contacts mission. The case was investigated, recommendations were developed, and eventually, 3 years later, so within a fairly short period of time, the UAE adopted a law that banned the use of all children below the age of 18 from participating in camel racing. And in collaboration with UNICEF, more than 4,000 children were repatriated to their home countries. So a very concrete example of how the international treaty body system can work in conjunction with civil society organizations, the labor movement, and governments who ultimately are accountable and responsible for the elimination of forced labor. The other example I'd like to share very briefly is the case of Myanmar. Again, a very different set of challenges where forced labor was essentially linked to the military regime that was in power in Myanmar, and which systematically used civilians for the purpose of infrastructure construction, road construction. They've used civilians for porter services in different parts, often linked to military action, as minesweepers. So it was a clear case of systematic imposition of forced labor by state authorities. And there was even a law in place, the so-called Village Administration Tract, which condoned the use of forced labor by the military and other state authorities. The case was brought to the attention of the ILO more than 30 years ago. So Myanmar, as opposed to the story I've just shared, is a longer story of change. It is not something, and we knew this from the start, the ILO's bodies, governing bodies knew that this would be a challenging case because it's linked to the complicity of the state. Now, in this case, the ILO used all its means at disposal in terms of its standard setting and supervisory bodies. A commission of inquiry was set up. The commission of inquiry developed very clear recommendations to the government of Myanmar, which at the time the government refused to take into account. And then in 2000, and this was an unprecedented case, the ILO invoked a constitutional article, it's in the Article 33, which allows the ILO to call on all its members to take all necessary measures to end forced labor in this case in a particular countries and not to be complicit, not to support forced labor in those countries, which as a consequence led to many companies and business to stop their operations in Myanmar and governments to reconsider their bilateral relations with Myanmar, which as a result, a few years later then, led the governments of Myanmar to accept the ILO's presence in its country. We were able to open an office, and we've even set up a complaints mechanism which allowed citizens to submit complaints to a neutral body, and the ILO then settled those cases with the government. Thousands of cases have been dealt with since 2007, and we still receive allegations of forced labor until today, but there is now a clear political will demonstrated through an agreement that the ILO signed with the government in 2012, where we now jointly work on an action plan to eliminate all forms of forced labor in the country of Myanmar. So another example where the issue of forced labor or slavery, however you prefer to call it, was intrinsically linked to a state system and which took much more time to change, but eventually change prevailed. And this is my key message. If we focus on our attention on those egregious violations, if there is concerted action from the international community involving multilateral organizations, but also civil society and business, we can make a difference. The last example, and very briefly, I won't go into detail, is the case of domestic workers, which I'd like to highlight here. Prior to the adoption of the ILO's Convention on Domestic Workers, in many countries of the world, domestic workers were not treated as workers. They were treated as unpaid labor, part of the family, maids. In short, largely women who can be exploited and abused, who can be disposed at will, who have no labor rights. And this changed dramatically with the adoption of the ILO's Convention on Domestic Workers in 2011. For the first time in history, domestic workers are now recognized as workers. They have the right to organize themselves, they have the right to claim their rights, and it has dramatically helped them to prevent abuse and to protect themselves. And I myself, I've attended a number of meetings where domestic workers, and often many of them are migrant workers, as we know, for the first time came together and organized themselves. By the way, very often on the premises of church, in church houses, and often on Sundays, because that's their only day off. And I can tell you there's nothing more powerful in those examples where workers come together and organize themselves and raise their voice collectively. And this is the key message also of the ILO. We have to empower workers. It's not primarily about rescue and protection, it's primarily about empowerment. And workers will be empowered if you give them the right to organize themselves. And these rights of organization, unfortunately, are not yet recognized in all countries. And that's a key priority for the ILO to address in the next years. So in short, coming to the conclusions, what can we learn from these examples? What does it mean? What does it mean to generate change? So just to reiterate what I said in the beginning, criminalization is a very important starting point to set the legal boundaries between socially acceptable and socially unacceptable behavior. And enforcement is equally important. So criminalization, yes, but we have to go beyond. And by the way, the progress we have seen in recent years, and I think my colleague from UNODC would certainly share this view, is tremendous in terms of countries adopting legislation to criminalize trafficking or forced labor and related offenses. So we have clearly seen a lot of progress on this side, criminalization. But now it's time to go beyond. It's time to address the root causes and really invest in prevention strategies and empowerment. And as I explained, international treaties like the ILO's conventions, like the Palermo Protocol, they set important benchmarks. And their ratification is not just a symbolic act, it's also political. And I hope I've been able to show you through some of the cases that it does have an impact. If countries ratify, they actually agree to become part of an international system of supervision that will monitor the situation and bring countries into compliance. And what is equally important, and it's my second point, that it takes sometimes time to address deeply entrenched practices of exploitation and abuse. It's not just a vice or an unhealthy practice which you can change because you have an intrinsic interest to change. The system, the exploitation and abuse that we see today in our economies is part and parcel of an economic system which has brought, no doubt, wealth and well-being for many people, but it has also exacerbated inequalities and social exclusion. And therefore, criminal justice needs to be embedded in a broader system and broader policies promoting social justice, in particular labor justice and good migration governance. The joint promotion of those broader systems of justice is not an option, it's a necessity if we want to win the struggle against slavery. Thank you very much.